Okay, ladies and gentlemen, we are going to begin. Sorry for the lateness. We have numbers of members who are either testifying in other committees or actually there one or two are out of commission health-wise. So for those, are we streaming? Yes. For those watching, just because the seats are not filled does not mean our colleagues are not working. I know a number of our on virtual bill hearings with other House committees. So we have a number of House bills today. We're going to start with Delegate Pena-Melnick. I made you a doctor. We're going to start with HB 355, Prince George's County Delegation, Board of Education Workgroup Alterations and Orientation. Then we'll follow with Delegate Washington, and then Delegate Ivey. Delegate Ivey has two bills, and then we'll three bills. The list goes on and on and on. And then we'll have Delegate Lutke, and as others come in, Delegate Guyton.
Thank you
Madam
so
Delegate,
much.
welcome.
Thank you so much, and good afternoon, Chairman Pinsky, Vice Chair Kagan, and members of the committee. It is an honor to be here with you to present House Bill 355. With me today, I have Delegate Ivey and also the Chairman of the Prince George's County Council, Mr. Hawkins. So House Bill 355 does the following, and it came from a process of months of working with different stakeholders. Current board members, the chair, the county executive's office, in addition, past board members and current board members as well, so that we could present to you this bill. So it commits to a return to an all-elected board with each candidate elected from one of the 9 Prince George's County School Board districts in 2024. Beginning on December 5th, 2022, the county board shall elect a chair and vice chair of the county board from among the members of the county board. And it creates a work group, and this is where it really matters. They will examine best practices among other Board of Education to strengthen the performance of the Prince George's County Board of Education. In recent years, the Board of Education has been embroiled in controversy centered on the structure of the board and concerns about transparency. There's an understanding that the structure of the board has become an important priority to the community. In recognition of this community perspective, the County Board of Education Transportation Task Force, which is a group that the county executive put together, recommended, after many meetings, a return to an all-elected board. The 2 steps above are aligned with this local input and will ensure that our community's voice is heard. We have heard from members of the education sector across Prince George's County saying that the adjusting of the structure of the board will have a limited impact if we went back to an all-elected board without a more comprehensive approach. Therefore, the third thing this bill does is that it creates a work group that will critically examine several factors to maximize the performance of the board. We cannot afford to rush into a solution that will bring us right back to this current position in a few years, because we have been here many times. So we want to do it well. We want to do it slowly. So we're bringing everyone to the table to guarantee that we get this right. Because at the end of the day, it's our children who suffer when we embarrass ourselves. It's our children that suffer when we don't work together. So this bill brings everyone together. And I asked that you give it a favorable report. We worked really hard. We met for more than 7 times with everyone. And what you have here is a consensus bill. And I respectfully request your support. Thank you so much.
Thank you. Chair Hawkins or Delegate Ivey, don't be bashful. You normally aren't. So please.
Well, thank you, Mr. Chairman, members of the Senate Education, Health and Environmental Affairs Committee. For the record, Delegate Julian Ivey here co-presenting House Bill 355. This is a consensus piece of legislation, and I just want to commend Delegate Pena-Melnick and others, members of the House, for the work that they have done to get this piece of legislation to the posture that it's in. This is truly a piece of consensus legislation to the point where it passed out of the House delegation unanimously. And about a decade ago, a similar piece of legislation was proposed to make changes to our Board of Education structure, and it was nearly unanimous, but it wasn't completely unanimous. So I want to be brief, and I'm very mindful of your time here at this committee, but I wanted to make sure that we all understood that we as a county are on the same page, and we'd like to make these solutions, implement these solutions all at once, starting in 2024 after the work group has completed its work. So thank you again for your time.
Thank you, Delegate. And we do have the pleasure of the Chair of the Prince George's County Council, Calvin Hawkins. Good to see you, Mr. Chairman.
Good to see you, and good afternoon, Chair Pinsky, members of the Senate Finance Committee, and to my good friend, Senator Ellis. It's good to see you again. I appreciate the opportunity to join with Delegate Pinnock Melnick and Delegate Ivy today to express Prince George's County Council's support of HB 355 as amended by the Prince George's House delegation. This bill, as amended, among other things, establishes a work group to study ways to improve the county's Board of Education, returning the board to an all-elected body, and allow the board to elect its own leadership. The council believes the amended bill represents consensus of all stakeholders and take important steps towards putting the school board in the best position to do its part in improving student outcomes. The committee should have the council's position statement indicating our support of the amended bill that came out of the House, and we look forward to working with our Senate delegation as we did in the House. Lastly, we understand that as the bill moved out of the House and Ways and Means Committee, there was a drafting error regarding the council's representation on the work group, and we appreciate the efforts to correct that error. Our position statement also mentions some issues we hope will be included in the work group study, and we look forward to participating in the work group's deliberation. Senator Pinsky, thanks again for the opportunity to testify on this important legislation, and the council urges your favorable vote on HB 350. Again, thank you for your time.
Thank you all. Questions? Seeing none. Thank you. And again, I want to thank Delegate Jocelyn Melnick, who's put a lot of time over the last 6 to 8 weeks on trying to pull this together. So thank you, Delegate.
Thank you for your work.
Thank you.
Have a great afternoon.
Thank you. That concludes the hearing on that legislation. Delegate, hang around, but I'm going to come right back to you. Delegate Washington, this is 1163, primary and secondary education, virtual education.
Should I just switch? Thank you. Good afternoon, Mr. Chairman, members of the committee. My name is Alonzo Washington, for the record, here to present on House Bill 1163. House Bill 1163 represents a about 6-month working group product from the speakers, staff, and working with different outside groups to come together to figure out what was the best methods to make sure that we have adequate and superior world-class service to our students during a pandemic or otherwise. That would be virtual, that would add to virtual learning for our students. I know this committee, along with others, have worked on a similar piece of legislation that we have in front of us in Ways and Means that we'll consider and have a public hearing on Thursday. But this bill, particularly House Bill 1163, provides robust infrastructure to ensure our school systems are prepared and adequately equipped when students are required to learn remotely. This ongoing preparation is key to ensuring that students don't lose valuable learning time should circumstances require the implementation of virtual learning, such as a deadly pandemic like we just experienced. This bill includes provisions to equip teachers for virtual learning by establishing best practices and requiring training, expanding virtual learning infrastructure, and comprehensively engaging students and their families. This sweeping piece of legislation would prepare our educators and our schools to minimize the real and devastating effects of learning loss. In a time where we can see a distinct and unprecedented widening of the the achievement gap as our most vulnerable students, students of color, low-income students, and students with disabilities succumb to the difficulties of remote learning. It is our imperative to do everything we can to ensure that this never happens again. There are differences between our bills. We will rectify them and see what the best practices and we'll see what the best route we can take to make sure that we can move both pieces of legislation. With that being said, Mr. Chairman, I strongly urge a fair report on House Bill 1163.
Okay, Mr. Willems, I saw John a minute ago. You still here? No? Okay, well,
He's going to see if he's outside. real
okay,
quick. I know they support it with amendments.
right. Okay, well, we'll let him come in if he returns. Questions for the delegate? Obviously, we heard Bill, the same topic. I think there's some commonality, some differences, and hopefully we can have a conversation and get the best work product from the two bills. Senator Riley.
Thank you very much, Mr. Chair. Delegate, again, a bill that I have a great deal of interest in, but in the fiscal summary, it says that no virtual schools may be approved for operation before July 1, 2024. Aren't there several virtual schools already operating? How would this bill affect them?
It wouldn't. They will still be able to operate. This is for new schools.
New schools?
Correct. New virtual schools. So
yeah.
it puts a pause on on developing any new schools for the purposes of studying virtual schools and allowing MSDE to do its work, to take a look at what happened during the pandemic and look at the learning loss and think of best practices and the best ways to really roll out the full implementation of a virtual school. I understand the bill that this committee voted out, and that's in the Ways and Means Committee, allows for multiple virtual schools. But this bill does not. I know on the Eastern Shore, there are schools already forming or schools already there, and so this doesn't cover them. They can continue to do what they can continue as a virtual school.
And the other question is, does this affect public charter schools like Anne Arundel would offer?
Those are public schools.
Okay, and what about regular charter schools
Those are public schools.
in every jurisdiction?
Correct.
Okay, thank you. Thank you, Mr. Chair.
Just to reiterate, charter schools are public schools under the state law.
Right.
Delegate Washington, do you come up with a definition of defining a virtual school? I know that's been a question of definition, and a lot of people want to know what that is because there are, as you know, virtual programs. There are courses on the Eastern Shore, a Chinese or advanced physics course. So I didn't have a chance to skim through this to find out definition. Do you address that issue?
We do. We define what a virtual school is, what a temporary virtual school is, and what an actual virtual school is. We also define what a virtual education class is in the bill and how that can be implemented here. We do provide a grant of about $500,000 for virtual education courses for students.
Mr. Willems, you want to come up? You were signed up, I think, favorable with amendments before we conclude the hearing. If you'd like to share your perspective on this.
Mr. Chairman, members of the committee, John Willems, representing the Maryland Association of Boards of Education, here today to testify in support with amendments on House Bill 1163. This is the bill that we put considerable work and effort into at the end of last session, and we were presuming it would be the vehicle for a lot of our work this session. We ended up working on this side of the street for a significant amount of time on a rather different bill. There are some similar provisions. There are some differences, particularly in the language around the availability of the use of for-profit services, whether it be for the day-to-day operation or, and my testimony points that out. So the Senate bill would prohibit the contracts for for-profit entities to operate or administer a school. The House bill refers to the day-to-day operations. We appreciate this committee's efforts to provide guardrails in that respect, but we do think there's an appropriate role for for-profit entities. And so however the committee determines to rectify that language, we are very interested in preserving the opportunity for the blended virtual learning program on the Eastern Shore and the role of a for-profit provider in facilitating those services. And so want to go on record as supporting that. As to other distinctions in the bill, we want as much flexibility to develop courses and offerings within schools and appreciate that the guardrails need to be narrowly tailored to address the establishment of virtual schools. And we appreciate the leadership of the chair in this committee and Vice Chair Washington and leaders on the House to understand and appreciate that distinction. And those are similar provisions really related to both bills.
Well, I'm sure over the next week or so, we'll work some of these differences out. But Mr. Williams, did I hear you say that you support owning or operating a public virtual school by a for-profit entity? Is that what you said?
No. We do support the role of a for-profit entity in the day-to-day operation of a virtual school.
I'm not sure what day-to-day operation means. Either someone has primary responsibility to operate a school, and we said, at least in the charter school bill, you can't do that. You can't, we prohibited for-profits, and we didn't say a nonprofit could hire some for-profit to run the show. It's like cover. And so, as you know, in our bill, we allowed for goods and for services to be offered by for-profits, but I'm still unclear on that term, and maybe the good delegate and I can work it out, and I think we're probably on the same page or close to it. But at some point, I'm going to want a clarification of what you mean by day-to-day operation, because I'd be surprised if any of your local boards of education would be willing to hand over day-to-day operation of your public schools to a for-profit entity. I haven't seen that happen in the 24 jurisdictions.
Right, but, Mr. Chairman, if I could, but by contract with a for-profit entity, what we encountered in the charter school analogous scenario was the for-profit entities established not-for-profit variations of themselves who then became eligible to participate. And that may be an evolution that occurs here with regard to operators of virtual schools. I don't know. But the real issue is the accountability and the oversight of the public school systems in establishing these relationships and entering into these contracts and being held accountable, as I believe the bill intends to do, for the not only operation of the school, but the success of the educational programs being offered.
Well, and I can remind you, last year, the year before, we passed a law saying that for-profit higher education institutions could not finesse and create a new entity when they're essentially the same thing. And I don't believe our work in charter schools or virtual schools want to allow the same thing. Just, lipstick on a pig is still a pig. So I hope MABE continues to uphold public education in 24 jurisdictions. Thank you. Senator Washington.
Thank you. I too, I was a little taken aback by that statement, but I'm going to actually ask thank you for this bill, Vice Chairman. I thank you also for taking on the definitions of virtual schools. I wanted to clarify and better understand, and it's on page 12, lines 3 is where you talk about temporary virtual school. So I guess what is that? Maybe rather than I tell you what I think it means, why don't you tell me what a temporary virtual school is?
No, thank you for the question, Senator. I think what we're trying to do is try to find an understanding when there's a school that's either there's something that catastrophic happens where there's like a pandemic happens where there's a temporary virtual school and a school closes down and then this school has a virtual school temporarily, or during the transition from an in-person school to a actual school itself, actual virtual school itself.
So this is virtual, so this is a tradition, this is a in-person school, a traditional school that utilizes virtual schooling or utilizes, online delivery of content in an emergency situation.
Correct.
Okay, so it's kind of similar, I think we passed a bill also, and it'd be in your possession to allow schools to use virtual learning when there's snow days. Is it that kind of thing, and that would be called a virtual school?
No, not
Yeah, I'm
quite. We
trying to-
decided not to take that piece of it up about snow days or
Right,
eliminating
yeah,
snow
but
days in virtual school. So this isn't that. This is like a different type of emergency, like a catastrophic emergency. This isn't like, or something happens at the school where the school has to shut down for a long period of time.
Yeah,
This
so-
isn't a school day off
Got it.
or snow days or anything like that.
Right, and so I think that's where, just in that provision, so Waverly Elementary School in my district is Waverly Elementary School, and then there might be an occasion where they need to use online learning for a period of time. Waverly Elementary School, in my mind, doesn't become a virtual school. It's still a school, it's still a traditional school that is utilizing online to deliver for a short period of time. So I think I'd like to, I don't know the temporary virtual schooling. I'd like to see us sort of make a virtual school really be something more like what you're saying in F and F, where really, and G, where it's predominantly that's what it's doing. So what are your just initial
No, that's,
thoughts
I mean,
on
that,
that?
no, I hear you, that's right. I mean, virtual education means how you educate a student virtually through the
Yeah,
internet.
yeah.
Then virtual school means that's a permanent school that's designated
Right.
by an actual board itself
Yeah.
as a virtual school. And then you have the temporary virtual school, which is like during the
Right.
pandemic, which is what
Yeah.
which is what we've had over the last 2 years, right?
Yeah.
And so we try to define what that means
Right.
in definition so that, because it wasn't clearly defined
No,
about, you know what I mean? So we took a stab at this is what a temporary virtual school is. So what we've done during the last 2 years during the pandemic, those would be considered temporary virtual
Right,
schools.
I got you. So my stab back is that it's not a temporary virtual school and that it's temporarily utilizing virtual schooling. And so that's all. But I like, again, that you attempted to do that. And, yeah, thank you
Yep.
for clarification.
Thank you.
on that.
Okay, seeing no further questions, thank you both for your patience and your testimony.
Thank you.
Delegate Ivy, why don't you come on back up? I think you've got a number of bills. I've got 467, 468, and 1305. So let's rock and roll.
Thank you, Mr. Chair. Members of the committee, again, for the record, Delegate Julian Ivy here presenting House Bill 467. This legislation was proposed in 2020 by Senator Smith, passed out of the Senate unanimously. I believe it's a simple bill. It's been requested by the Montessori community to make it easier to hire and hold on to Montessori teachers in our public school systems. This bill allows an individual to be eligible for a certificate to teach students in a public Montessori school. And I want to emphasize that once you receive this certificate, you can only teach within Montessori programs. You can't teach in other public programs. You must hold a valid credential from a specified Montessori teacher preparation program. A couple examples, the American Montessori Society, the Association Montessori Internationale, or a program accredited by the Montessori Accreditation Council for Teacher Education. They must also hold a degree, a bachelor's degree in any field, and the State Board of Education may still require an individual to successfully pass an examination to be certified. While we have a teacher shortage across the state and across the country, finding ways to let teachers teach is really important for us to be able to get through this crisis specifically. I'd like to highlight the support from Dr. Monica Goldson, the CEO of the Prince George's County Public School System, in addition to Montessori teachers and associations, and also my favorite member of the Prince George's County Council. The legislation passed out of the House unanimously, and I'm asking for a favorable report.
Questions for the delegate? Delegate, it passed the Senate, like you said, 2 years ago.
Yeah, yes, sir.
Do you know if Ways and Means has changed their mind on this?
Yeah, it passed out of
right.
Ways and Means unanimously this
Oh,
year.
yeah.
Yeah.
Yeah, it's late. Okay, questions? Senator Ellis?
Yeah, thank you, Mr. Chairman, Delegate Ivey, thank you for this. So if you could break it down for me, I'm trying to read and listen at the same time, so not always done well. So could you explain to me, so this bill would allow Montessori school teachers to have a parallel certification as those in the public schools?
Well, truthfully, there are private Montessori teachers who would love to come and teach within our public schools, but they have to go through the entire process to become a certified teacher when they've been teaching for 10-plus years, et cetera. And so, truthfully, to allow these individuals to come and teach in our public school system without having to go through the entire certification process that they traditionally would go through to teach in our public schools, that's what this bill is allowing.
So it's allowing them to leave Montessori school and come into the public schools with certification equivalent to the public school teachers?
If they pass a examination created by the State Board of Education, if they also hold a bachelor's degree in any field and a valid credential from these various sources as well.
But, Senator, it's to teach in a Montessori school.
Yes.
It's not just to teach English at a traditional school. It's if they have the certification from Montessori, rather than follow through the normal traditional pedagogy and other courses the state requires, if they've been certified in one of the three areas, they can come to a public Montessori school and teach. There are not a whole lot of them around the state, to be
Right.
honest with you. But
So public Montessori schools?
correct.
I didn't know that existed, so thank you for that knowledge.
There are a few of
Mr.
them. We actually have
Okay.
one or two in Prince George's County.
Okay, so public Montessori schools, which is similar to, it's like a charter school?
Robert Goddard Montessori, it's a
Okay.
pretty good one. I attended there. It's in the Senator's District as
Yeah.
well.
Okay,
Yes, sir.
great.
But they won't be able to teach non-Montessori programs, okay? They'd
I
have to go
see.
through the entire certification process to
Yeah.
teach.
So the certification, the examination you're referring to, is that, you mentioned provided by the State Board?
Yep.
So I know the praxis series, is that a qualifying exam, or?
The State Board would be able to decide what exactly that examination would consist
Okay,
of.
great, thank you.
Absolutely.
Questions for the good delegate? Senator Washington.
Thank you very much. And I asked this question, having supported the bill
Sure.
last year and having had sisters educated in the Montessori and also a child. So,
Absolutely.
but the Baltimore City gave a letter of information, just expressing concern about that there are two teaching standards. And specifically, they asserted that the Montessori Accreditation Council for Teacher Education did not align with what Maryland's expectations are. Can you just address that?
I'd have to look further into the disalignment, Senator.
Okay.
But it, to my understanding, that, they do allow for this accreditation to
Right.
teach Montessori just generally, and to allow them to also use that accreditation to be certified here to teach in our public schools. That's the idea of the legislation.
And then just also more broadly,
Sure.
specifically, charter schools are allowed flexibility in their curriculum and content, but all teachers have to teach to the Maryland teaching standards. Would that be correct? Yeah,
Absolutely.
okay. All right, thank you so much.
Thank you.
Okay, thank you. That completes the hearing on your first bill. The other two, hopefully they'll be sure to have the chairman of Budget and Tax, who's, I'd like to slide in, but we'll keep going. Why don't you go to the, well, we did that one. Which is it? Can we do 1305?
I'm not sure if that's the most straightforward of the rest of the legislation here, but thank you again, Senator Penske, members of the committee. For the record, Delegate Julian Ivey here presenting House Bill 1305. This legislation establishes specific eligibility requirements for private Montessori schools and programs which are seeking to take part in the pre-kindergarten expansion grant. Y'all are well aware of the pre-kindergarten expansion grant established in 2018. As presented, this bill would amend the staffing and area requirements under the pre-kindergarten expansion grant program for non-public Montessori schools, non-public, or Montessori programs in non-public schools, stating that in classrooms that contain both children younger than age 5 and children at least age 5, that these classrooms shall maintain at least one teacher and one teacher's aide in every classroom with 25 or fewer students, maintain at least one teacher and two teachers' aides in every classroom with at least 26 and fewer than 36 students, and maintain a student-to-classroom area ratio of 1 to 30 square feet. This piece of legislation, we've been working on it in the House for quite some time, working with various advocates to try and open up this pre-kindergarten expansion grant program to these private schools. And I do look forward to your expertise and your willingness to work on this legislation as well. But in its current form, I'm asking for a favorable report on House Bill 1305. It did pass out of Ways and Means unanimously, and also the House of Delegates as well.
And I have no one signed up in opposition, either orally or written.
Yep.
Seeing no questions, it was straightforward. Thank you very much.
Thank you.
There's nobody else signed up but yourself for 468. Let's go into that, and I think we can probably move through this quickly and then take the chairman.
I really appreciate it, Senator, and to the chairman as well, for your indulgence. For the record, Delegate Julian Ivey here presenting House Bill 468. Current state law already provides for protections for whistleblowers who are public school employees. They're already given the ability to take civil action against their local public school system. However, and really this is the important part of the legislation, quote, any administrative remedies must be exhausted, end quote, before being able to do so, to take those civil actions. This language is too vague, it's too broad, and in combination with the current 6-month time frame that whistleblowers have to exhaust these administrative remedies, there have been complaints and concerns of school systems slowing down the process so that it expires the 6-month time frame to take action. And so in its current form, House Bill 468 repeals that prerequisite that a public school employee whistleblower must exhaust all of these administrative remedies before instituting a civil action against a public school employer. It also requires public school employers to provide an administrative remedial process and complete the process within 30 days of the complaint being filed. That's to ensure that they're not just running out the clock. The legislation also extends from 6 months to 9 months the limitation of when civil actions can be brought. This legislation passed out of Ways and Means and the House unanimously. A dear mentor of mine, former Delegate Jimmy Tarlow, has been working with me for years to push this legislation as well. And so we're all asking for a favorable report.
Okay, thank you, Delegate. I will have folks note there is written testimony for and against, so I think when we do a markup, people should in advance spend a little time looking at the, there's some debate and discussion on this issue, although they've been kind enough not to sign up for oral testimony, so I appreciate that. I think I had Senator Carrozza and Senator Ellis.
Thank you, Mr. Chair, and thank you, Delegate, for the bills today. I'm just really more a process question, trying to understand when you mentioned this bill exhausting, I'm trying to understand that if a public school employee, becomes a whistleblower,
And are retaliated against.
what's that?
And are
So
retaliated against.
can you just walk me through the process of what, in that situation, and then, and your mention of exhausting everything before civil action?
Sure. Whistleblower comes forward, makes their complaint. The administrator then punishes them for coming forward. And then there are already whistleblower protections in place, but, you have to exhaust any administrative remedies before you can institute a civil action. However, it doesn't tell you a process to actually exhaust those administrative remedies. And because it's vague, because it's so broad, there needs to be a little bit of clarification. And that's the crux of the legislation, requiring that public school employers create and provide this administrative remedial process, and require that it take place within 30 days of that complaint being brought to the public schools.
So we're trying to have a clear process.
Exactly.
But we're still trying to exhaust that action before we would go legal?
Exactly.
Okay.
Yeah, make it very clear.
Okay.
You have to go through these steps before you can take it, the civil action.
Okay. Thank you.
direction.
Senator Ellis.
Thank you, Mr. Chairman. The good senator asked and the good delegate answered my question, so thank you.
Thank you. That was fairly easy until
you.
we start marking it up. Thank you, Delegate. I think that's it for you today.
I really appreciate
Thanks for
it.
your time and your patience. Chairman Gazone, we're going to shift to 10:06, hemp farming program, use of hemp and hemp products in consumable products.
If I could bring up the little group
Yeah,
here.
Abigail Deal, Anna Cheney, Kevin Addix.
Thank you, Mr. Chairman. Thank you for taking this late-filed bill. I think it's important in particular for our farming community, folks who are out there hemp farming. I know that you had a bill, as a matter of fact, I saw on the floor today, where you're trying to help the industry. This would be a big step in that regard. There's some technical aspects to this, and I have a technical amendment that we'll submit at the end. But for me, it's just sort of broadly thinking that I can go on the internet right now and buy any number of products with hemp in it. But farmers in Maryland can't produce that hemp and put it in their own products for sale in the state. And so this is really about, in my mind, bringing some equality, equity. We've been doing this all for a while now in budget and tax, dealing with all kinds of internet businesses, and we dealt with them from a tax standpoint. But this one is really just about the ability to produce and include and sell within your own state. It does several things. That's the big one. But it also helps farmers. There's some situations where they've gotten jammed up because levels of THC, which is in hemp, but not at the intoxicating level, that if it's slightly above a limit, they have to destroy their entire crop, which has been very problematic in terms of keeping the industry moving forward. There's a solution, and the solution is a pretty simple one that allows for a reduction of that level in the processing process. And so that's essentially what the bill does. I'm going to let the panel, who is much more knowledgeable about these matters, throw in on this.
I believe Ms. Deal is first.
Thank you, everyone, for being here, and thank you for your time. I'll keep it short because I know that everyone's tight today. Just want to say that that's basically at the farmers right now, it's detrimental to their farms right now in having to burn their entire crop and losing all of their money and energy that they've spent time and energy growing. This is a very easy remediation clause that we allow for a lot of other industries that they're able to take a product that might not meet the criteria and make it into a product that then is legal, and then they don't have to destroy everything and then continue on with their farm. So I fully support this, and it supports all of our Maryland farmers, which is desperately needed. So please, thank you very much for your support.
Thank you for your conciseness. We'll have the other two panelists go, and then we'll open up the questions. Please, in whatever order you choose.
Thank you. My name is Anna Cheney, and I am a hemp farmer. My two kids and I, my third is somewhat involved, a little bit young, but we do grow hemp on our farm. We have for 3 years, and this bill is absolutely vital with the amendments to the sustainability of our farm. We've grown 40 different species for the last 8 years, and when we started growing hemp, we realized quickly that this product would allow us to get our farm into sustainability and the ability to continue farming for generations to come. So we do hope that you support this bill with amendments, and I'm open for any questions that you have regarding this bill or our hemp crops and how popular this product has become for our on-farm store. We have a small store, and we do rely on that store for our income. And this is absolutely vital, not only to our family farm, but to many small family farms in the state of Maryland. So I do thank you so much for your consideration. I am here for you, and I thank you for being here for me.
Thank you. Mr. Addicks, welcome.
Thank you, Mr. Chair, and members of the committee. Kevin Addicks with Grow and Fortify, representing the Maryland Hemp Coalition. And I will keep it very simple and say that the coalition of grower and processor members strongly supports this bill, and we urge a favorable report. Thank you.
Let me start. Senator, you can go. Senator Riley.
Thank you.
Could you share with the committee what types of products you sell at your store?
Absolutely. So we sell not only our hemp products, but also we sell honey and a variety of herbal teas and tinctures that we produce from our crops. With regards to the hemp, we sell our hemp CBD oil, which people use for joint pain, muscle aches. They use it for anxiety, sleep. It does not have intoxicating effects whatsoever. It always tests below. We do use very excellent processors in the state of Maryland. We keep it all in Maryland. And our guests are just so happy. I mean, I have people who've been on medications for years, and I can just see this one gentleman who comes very regularly, and a professional, many people probably here know him, and he loves the product because it actually is natural. He doesn't have to worry about side effects, and it helps him feel better and sleep and have less pain. So the CBD is amazing. They're also, we sell bath salts and an actual salve. We would love to be able to produce more value-added products, and we can definitely do that within the confines of all the regulations, the definition, the legal definition at the federal level of hemp, once this bill is passed, and we do appreciate that very much. Thank you.
What are bath salts?
Bath salts are made with Epsom salts, black sea salt, and you put them in your bath. It's got a little bit of CBD oil in it, so it will literally help you with joint pain. It also is detoxifying. So I happen to run detox programs. I'm a certified functional nutrition counselor, and it's really helpful when people go through my 10-day plan. I'm on it right now, as a matter of fact.
Thank
So
you very
yeah,
much.
thank you.
Thank you, Mr. Chair.
Yeah, thank you, Mr. Chairman. And Mr. Chairman, thank you for presenting this bill. Anything to help farmers is very important to our community, our state. So you mentioned if you have a crop that's above a certain limit, now you have to destroy it. So who sets that limit as far as the THC is concerned?
Sorry. Oh, yeah. So the federal bill allows us, they have a leeway that would be, how do you say it, complicit with this bill that you're proposing right now, that you're thinking about, because they allow that variance and allow us to remediate. So we would be in compliance with that. So it is MDA, Maryland Department of Ag.
So Maryland, is the state set that limit?
The feds, and then we set it as well. So we have that opportunity to do that, yes.
Okay, so the federal government has the limit, and so can Maryland go below that or generally above? Is that
Generally either the same or below.
the same or
Yeah.
below? Okay. And so the issue is with the state,
Correct.
and so this bill would, is that take away that limit, or I'm not sure what it would do?
Yes, so basically, this bill would allow, what happens is, so the definition of hemp is 0.3% THC or less. And what the federal, I think they called it like regulations based on the last bill, they allow you to remediate between 0.3 and 1, is my understanding. And so we are just trying to do the same thing here so that if there are some testing concerns that when you test the entire plant, you're going to get what that entire plant will provide, which is generally, as a hemp plant, 0.3% or less, because we only use the seeds that are supposed to produce 0.3% or less. This plant is very responsive to climate changes, and it doesn't like stress. It's a really neat plant, by the way. So when it gets stressed, it can produce a little bit more or less of what we would like ideally. But it is at no fault of any grower that this happens. This is an act of God. So everyone knows that. That actually has to work with the plant, meaning that it's not negligence. We're not trying to grow something else. We're growing hemp. We don't want to grow anything else. So if it tests at 0.4%, which I don't know, I'm not an expert in cannabis, in the medical marijuana, but I've heard that they're growing plants that produce 27+% THC. We're talking about 0.3%. So if my plant tests at 0.4 because they've chosen one specific bud off of one plant that happens to be at the top of the plant, which generally has the most THC in it, and it's at 0.4, but had they taken buds from that whole plant, it would test at 0.1 or 0.01, then now all of a sudden I have to destroy my entire crop. And I really have done nothing wrong. So this helps us tremendously as small farms in the entire state. And many of us have not gotten our licenses this year because we don't want to do something wrong. And we don't, you know how much effort that is to put into acres or even less than an acre of hemp. I mean, you have to watch every single plant every day to make sure it's doing the right thing. So, yeah, thank you.
Thank you so much for that.
Absolutely.
Horticultural lesson.
Thank you. Thank you.
Let me follow up. I haven't seen the amendment. What does the amendment actually do? In other words, I heard your explanation about the 0.3 and up to 1%, and that you don't want to destroy the whole crop. When we set policy statewide, we have to set a policy for people who might sometimes be untoward and come up with a hybrid. So we want to ensure public safety, or
Absolutely.
At least they know what they're getting. So I guess my question is, what does the technical amendment do?
Yes. So basically, we still cannot sell something. No one is allowed to sell something that has more than 0.3% THC in it. That is fully regulated. So we have to test the final product coming out, of any farm store, any small farm store, any place in Maryland. If it's hemp, it has to be a product that contains 0.3% or less THC. This does not change that. This only allows us as farmers who tested at 0.4 or 0.5 or 0.8 to remediate that through the processing process, as the senator was mentioning, so that we can produce the crop, the product, the final product that is in compliance with the federal definition of hemp, which is 0.3% or less.
So do you do self-testing and self-reporting, or does the ag come out and do it?
No, we have to go to a certified lab and have it tested, third party, certified independent lab, third party tested, and then if you're doing any kind of banking in the state, you have to produce that to them quarterly. So they contact me quarterly and make sure that they're getting my latest lab reports as well. So MDA gets it. If you're working with an institution of higher education, they have to get it, and it has to be available to all of your clients. So all of my clients, all of my patrons, they all have access and copies of our full lab report.
So you pick the plants and bring them to the department?
Well, no,
or their agent or whatever?
No, this year they're actually sending out people to test it separately. So they'll take the sample, MDA will be taking the sample and sending it to the third-party lab on our dime, and then they will, give us those reports back. And so if we test it at, let's say, 0.4, they're going to come back and say, okay, you destroy your whole crop. So we've just lost, an entire year of planning, and all of anything that we would have made from that is now gone because we really didn't do anything wrong, but we got a bad rainstorm or a windstorm. The little plant got stressed, and it starts going crazy and producing, as many cannabinoids to try to save itself from the destiny that Mother Nature is bringing on.
So if it tests high, they will retest after you process it and you've brought down the THC?
Yes, with this bill, absolutely, 100%.
Thank you.
Yeah, thank you so much.
Other questions? Seeing none, I think that takes care of it. Thank you, Mr. Chairman. Thank
Thank
you,
you, Mr. Chairman.
witnesses.
Thank you very much.
Thank you for
Okay,
your
that
time.
concludes 10:06. Thank you all.
Thank you so much. Thank you.
Is Luke here? I see. Delegate Moon?
Thank you, Mr. Chair. So,
Delegate Moon, you'll be followed by Delegate Guyton. I just noticed you, Delegate.
great. Thank you, Mr. Chair. House Bill 146, it's pretty simple. It's been stripped down quite a bit by the Ways and Means Committee. It deals with a section of law regarding reportable offenses, and this is where if a student commits one of a listed offenses outside of school, it gets reported by law enforcement to the school. There was some concern that students with disabilities or special education students were not having the opportunity to have a manifestation determination as to whether the offense was related to their disability or not. And so the bill now clarifies that they have a right to an attorney for any of these to be present during any proceeding where they might be removed. And it just adds a reporting requirement to sort of get some information about how this practice is being currently handled and what's becoming of the students who get reported. The original bill was quite substantial and made many alterations to the substance of the law, but after much discussion, again, they stripped it to a report and a simple right to an attorney if one of these proceedings is happening.
Okay, I apologize. Let's have Megan Berger come up, Michael Gross, and John Willems. And then we'll take questions if you have a minute. I think, Ms. Berger, you're first.
Good afternoon, Megan Berger with Disability Rights Maryland, the state's protection and advocacy agency. We're here in strong support of HB 146 with a few friendly technical amendments. Under current reportable offense law, schools can unilaterally remove students from school for indefinite periods of time, many times months, when they receive notice that students have been arrested in the community for behavior that often has no nexus to school. When students are removed from school for a reportable offense, they have very few rights and due process protections, and the school has a lot of authority with very little oversight. This results in kids being removed and disconnected from school, and it triggers all of the harms of the school-to-prison pipeline. For students with disabilities, their rights are especially trampled by the current reportable offense law because students are not provided with the legally required manifestation determination review, and it therefore violates Federal Individuals with Disabilities Education Act and state special education law. In order to fix these problems and bring the current reportable offense law in line with state discipline law and federal and state special education law, HB 146 directs school systems to follow existing discipline procedures and protections for both general and special education students. HB 146 also requires that school systems invite the student's attorney to participate in the removal process, which ensures the student's rights are protected, and it also results in a more balanced and just process. Finally, HB 146 directs the Maryland State Department of Education to collect data from school systems on their use of reportable offenses, which is imperative for transparency and accountability purposes. The data requirement will allow lawmakers to monitor how school systems are using the reportable offense law and determine whether it's being used disproportionately against certain groups of students, which is of course our suspicion, given that there's, years and years of research showing that exclusionary discipline is used disproportionately against students of color and students with disabilities. Thank you.
Thank you. Excuse me. We'll hear from Ms. Gross, and then we'll take questions. Mr. Willems is unfavorable, so we'll do the proponents first, please.
Good afternoon, Mr. Chair and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent youth charged in both juvenile court and in criminal court. I'm here today testifying in support of HB 146, which would provide amendments to the reportable offenses for which a child can be removed from school. Section 70303 of the Education Article, the Reportable Offenses Law, is an extreme collateral consequence for youth who are involved in the criminal justice system, and it denies them their right to an education. Under the Reportable Offenses Law, students can be removed from school based on mere allegations that are entirely unrelated to the school, and for charges that may very well be dismissed. Some of the problems that we've seen with the Reportable Offenses Law, as everyone here knows, over the past 2 years, we've seen the effects of remote schooling on students. It's worked for some students, it's been terrible for most. What the Reportable Offenses Law does, though, it removes students and puts them in a position worse than a remote school, where everyone was in the same situation. Instead, these students are singled out, pulled from their educational environment, sometimes sent to an alternative school that doesn't offer the classes they need, such as special education classes or advanced placement classes. They're not allowed to participate in extracurricular activities like student government and athletics. Oftentimes, we see this happen to kids as young as 11 years old, who are too young for an alternative school, so they're removed from school after being charged for, let's say, a fight with a sibling at home, placed on home tutoring. Their parents can't transport them to the library, and so they spend 6th grade at home doing school through worksheets. And reportable offenses are being used in situations where removal is just not necessary for school safety. Children who are charged with very serious crimes are likely to be detained in juvenile court. And public safety, including school safety, is something that's addressed by the judge when determining whether or not that child can be safely returned to the community and used in determining the conditions of release. Right now, another problem that we see is that there's no data that's collected, but anecdotally, I can say that it's disparately applied to Black youth in the counties where I practice. HB 146 would fix some of these problems by requiring data collection and ensuring that due process is afforded to these students. There's still some additional problems, but
We're going to have to wrap up.
yes, I am wrapping up, Mr. Chair. Overall, this will offer protections to slow down the school-to-prison pipeline, and for these reasons, the Office of the Public Defender urges the committee to issue a favorable report on HB 146. I am happy to answer any questions that may come up as to the technical amendments that Ms. Berger mentioned.
Senator Washington.
Thank you, Delegate Moon, for this bill and this issue of reportable offenses. In my disciplinary disruption bill, I ran across reading that, and so I want to understand. So these are offenses that happen outside of the school, right? Does the offense have to be against another school student, or is it just anything? Yeah, and are all of the reportable offenses violent offenses? So could you give me an example of just what are some of the offenses that someone could be secluded or excluded from school, even though they're not in the school at the time of the?
And also her first question of, does it have to be a student or can it be anybody?
Yeah.
So just very briefly and
Yep.
to the point.
Thank you for the question, and I'll let my panel sweep up where I glitch on this. But no, it's not all violent offenses. It includes theft, drug, and some gang, weapon,
Yeah.
and violent crimes, but it's a mix, and no, it's not on school grounds. And this is sort of the question, you know, when you should use the school disciplinary process versus something else. But again, let me just reiterate, the bill as originally introduced came in with a whole lot of substantive changes.
Right.
It does not actually change any of that now.
No.
It leaves the existing process in place, simply adds reporting on who and under what circumstances these cases are handled. And as to substance, it's simply, again, about adhering to existing standards and a right to an attorney. And that's, I think, what they got consensus around, bipartisan consensus around, and all the rest got deleted out.
No, I understand, and just forgive me, Chair, I just want to clarify, because just when these bills come up and this
Yep.
topic, other things are often brought to it. So I thought in the course of the hearing, it might be good to just have on the record
Yep.
that this is not, you know, Stevie hit Johnny in school.
Right.
This is Stevie was smoking weed off campus, or any of these things, anywhere
And
near the school.
arrested, not
Arrested,
not
sorry,
adjudicated
arrested.
delinquents or
Right.
convicted, et cetera.
So they're arrested, okay. And then just the other question that I have, I appreciate the reporting that they're doing in the bill. And you're asking, is this per school? Are you also asking for it for
per
every
incident, I
school?
believe.
Per arrest? I just want to clarify.
I believe it's per reportable incident. So we'd have, yeah, it's what action was taken on that offense, the race, ethnicity,
Okay,
gender,
yeah.
for that offense. So this looks individualized to me.
All right, and then is it, I guess, again, I wanted to, in case there's an opportunity to further clarify it. So the intent is to know by local school and by each school level data, or, aggregating it up? Because if you aggregate it to the school system as a whole, it'd be less easy to identify the students. In other words, if you have a certain school systems, if you give the race of the student, you're gonna kind of know who they are, particularly if it's a school. So,
I understand what
yeah.
you're saying. Yeah, I mean, the way it's phrased doesn't require
Yeah.
publication with that level of detail, but the
But
reporting coming in may
So we
be
could
that
try to-
specific. Yep.
Great, thank you so much.
Thank you, Mr. Chair. And this is probably for the delegate. As I understand the bill, it is now primarily a reporting bill. And I just want to make sure I'm reading it correctly. Right now, the bill does not include for reporting the results of how students performed when they were actually, if they were removed from the school. In other words, we don't, at this point, we're not requiring data collection that might show student grades and attendance, what happened when the students were actually removed. That's not
That's
in the
right.
bill now, but might be, just from the standpoint, if this is a reporting bill and we're doing data collection, information about the student grades and attendance in those situations where they actually are removed, that could be helpful information for the data collection and reporting.
Sure. I would think so. It's not currently in here in that detail, but
Okay.
sure.
We might want to clarify that. Okay, thank you.
Yeah, thank you, Mr. Chairman. Delegate Millen, thank you for this bill. And following up on Senator Washington's questions on reportable offense. So reportable offense is something that a student does outside of the school, and they come in contact with law enforcement, and there is an arrest, and state law requires the law enforcement to report that arrest to the public schools.
Correct.
I'm sorry, I didn't hear you.
Correct, yes.
Okay. And so, after that point, what is required of the public schools when they get this reportable offense on a student? Does it trigger automatic disciplinary action by the school, or it's discretionary?
I believe it's discretionary, but let me defer to my panel on this one.
It is discretionary. However, in practice, because the reportable offense law affords students so little due process protections and rights, as opposed to the school discipline process, and there's very little oversight or limitations on what the school can and cannot do, in practice and representation of students across the state, we have seen essentially the unilateral removal of students for indefinite periods of time, without sort of the student or the parent being able to have a say, without any meaningful review or appeal processes.
Okay, thank you for that. Do you have any data on the percentage and the population group that's affected by this?
We don't. We filed a Public Information Act request to try to get that data, and many of the school systems weren't collecting it, which is one of the reasons why we felt the data collection piece in this bill is so critical, so that we can actually figure out how are school systems using it and what groups of students may they disproportionately be using it with.
So thank you. When you say that we file, who's the we you're referring to? We filed the Public Information Act. when you say we have filed, I mean, what
Sorry,
organization?
so several sort of advocacy organizations.
Okay, like, can you give me some names of your organization? Are you,
Yes.
okay, what's the?
Disability Rights Maryland.
Oh, Disability Rights Maryland.
Yes.
So to the public defender, could I ask a follow-up question, Mr. Chairman? Thank you. So you said you were in Southern Maryland? Okay, those are like, could be 3, 4 counties. Which counties, are you working all 3 or 4? Or?
I primarily practice in Charles County,
In
but
Charles
I
County.
do also
Okay.
practice in St. Mary's and Calvert
Okay,
occasionally.
so primarily Charles County is the county I represent wholly. So, how do you see that Charles County Public Schools enforce this reportable offense? Is it a lot of issues you deal with in your work with?
Yes, Charles, so part of the problem with reportable offenses is that it's not used in the same way across the state. Charles County is one of the jurisdictions, one of the school
Could
boards.
you speak more to the mic?
Yes, sorry about
Please,
that.
no problem.
Charles County is one of the school boards that does actually remove quite a few children. And the way that it happens is a child is arrested, for example, I was talking about an 11-year-old, arrested, charged for a fight at home. Their parent was notified unilaterally by the school principal, your child is being removed from school under state law. No explanation of what the state law is, no opportunity to present why removal is not actually necessary, no opportunity to present why the removal will actually harm the child more than help anyone out. The child's removed, either sent to an alternative school if they're old enough for that, sometimes just placed on home tutoring, where a tutor comes and meets with them once or twice a week. Sometimes when a tutor is not available to go to the child's home, or the child's not available to meet with the tutor at the library, it's just worksheets that they're given. They're removed from school for months, and then the day that the case is resolved, most often they're just placed right back in school without any sort of remedial services. The entire time that they're removed from school, they're not allowed to participate in extracurricular activities. They are not allowed to they quite often don't have any special education services, or their special education services are modified to accommodate the school placement that the public school system has determined was appropriate for that child. And quite often they are not allowed to take certain elective classes or advanced placement classes that were available for them at their home
Thank you.
school.
Okay, it's a long list of stuff. So thank you. I know you very intimate with that. So so what percentage of students, have you seen like disproportionality in Charles County? How would you rate it as
Right.
far as black versus any other group?
Almost every child that I have represented who has been removed for a reportable offense has been a black child, and most often they're black males, black boys.
So the system is disproportionately removing black males from the school system in a very arbitrary and capricious manner.
Based on the anecdotal data that I have from my personal representation and that my colleagues have from their representation.
Great. Thank you so much. And thank you, Mr. Chairman, for your time.
Okay, let's go to the opponent, Mr. Willems.
Mr. Chair, members of the committee, John Willems, representing the Maryland Association of Boards of Education. I'm here today to testify in support of House Bill 46 with amendments. And our testimony outlines 3 in particular. One, provision of the bill that remains problematic is the absolute right of a student to return to their school of origin after the time for which they were removed due to a reportable offense. That is in conflict with legislation passed by this committee last session regarding students who end up on the registered sex offender registry, and it's incongruous with other provisions of law with regard to students adjudicated for sex crimes. And so that provision needs to be addressed. We are concerned that we want to be clear that MABE supports the progressive disciplinary approach adopted by the state board with the goal of as much non-exclusionary, non-suspension and expulsion discipline as possible, but removing a student for a reportable offense is not discipline. Discipline of a student for off-campus activities has to have a nexus to the school environment, and has to be disruptive under Supreme Court cases and Maryland court cases. So this is a safety matter, not a discipline matter. And our student service directors certainly wanted me to emphasize the distinction between ensuring school safety by removing a student who poses a threat to school safety from student discipline. So it's a reassignment issue which is different than exclusionary discipline. And that's an important distinction. And so that goes to the concern in really the third amendment, that there are several provisions of this bill that are kind of drafted in the wrong place. They're reportable offense provisions that are drafted in the student discipline section, and they're actually drafted in the special education section of the student discipline section of the law. So they're really kind of buried in the wrong place in the statute. Dealing with reportable offense notifications and responses to those students shouldn't be conflated, in our view, with student discipline. Thank you.
So in terms of, you said, I thought I heard you say favorable with amendments. I know you signed up as unfavorable. I assume you're fine with the report, but you're not fine with returning to class because of legislation. So in other words, if someone, the reportable crime was assaulting someone of the other sex, we passed a law that says they didn't have a right to come back to their school. So I assume you want that removed. What else are you recommending be removed?
The reporting requirement, I didn't mention it orally, Mr. Chair, and apologize, but on page 6 in lines 21 through 23, and this is an issue that we've raised in the past on other bills, but we don't have all the information relative to reporting to MSDE on the outcomes of students arrested off premises, and so involving local law enforcement in the reporting, it would be extremely helpful so that multiple agencies are involved in reporting to MSDE on the outcomes for these students. And DJS, of course.
Aren't the local police departments required to inform the school if the person's under 18 or whatever the age is?
Yes, but not with regard to all of the outcomes. They just notify us of the arrest.
Okay.
And so in terms of the status of the paper arrest or the physical arrest and the adjudication and through the state's attorney's office as well, our amendment focuses on law enforcement and DJS.
And I may have missed it, John, the availability of attorney, do you have a problem with that?
No.
Okay. Okay, thank you. Seeing no further questions, that concludes the hearing on 146. Thank you for your patience. Delegate Moon, thank you for joining us. Delegate Guyton, Delegate Healy, have you worked out who's going first?
I think so. I have a voting session like right now, so I'd like to be very quick if I could.
Okay, Delegate.
You also have a voting session?
No, that's fine by me.
Yeah, okay.
But she's going to want a reciprocal action when a bill comes before your committee.
Absolutely, that's fine. I thank you very much for your patience.
164 committee.
Yeah, thank you very much, Mr. Chair, members of the committee. For the record, I'm Delegate Ann Healy. House Bill 164 is about public institutions of higher education, pregnant and parenting students policy. This basically codifies in Maryland law Title IX, the federal law, to protect pregnant and parenting students so that they don't lose their educational opportunities. This is similar, this is codified in California law recently, and this is the same kind of thing. It's basically, Title IX does provide a lot of protections, but if the federal law goes away or is modified, we would still have the protections in place in Maryland if this were to pass. In Maryland, most colleges do not list the Title IX rights of pregnant and parenting students on their website, but there are 55,000 student parents in Maryland, which is nearly 20% of undergrads. And pregnant or single moms have a very small chance, if they don't know what their rights are, if it's not on the website, if they're not informed, they may just give up on their education. And really, this is about informing them, putting it on the website, having a policy, and also supporting women who have recently had children, having a place for lactation that is not a closet or a bathroom. Simple things like that. That kind of accommodation is already required for employees, but it should also be required for students. And that is the short and sweet version of this. I'd be happy to answer any questions.
Thank you, Delegate Healy. It's good to have you in the Senate. Thank you for your leadership on this issue. I wonder if you could address the amendments, because the bill is significantly amended. Do you want to just talk about that?
Sure. The bill, as it came in originally, was drafted to include all institutions of higher education. The Appropriations Committee amended it to cover public institutions, including the community colleges and the public four-year schools. And I think I don't serve on that committee, but I believe it had to do with the fact that they have more clear purview over that. It passed unanimously out of the committee and out of the House of Delegates, and I hope it can have the same future here.
132 to 1. Who's the naysayer? Okay.
Oh, there is one. There's always one.
There's always one. I see no other questions for Delegate Healy. So thank you, Delegate. Go vote. That completes the hearing on House Bill 164. Be well.
Thank you very, very much.
Thank you. Next up, Delegate Guyton, House Bill 512, Professional Standards and Teacher Education Board, Composition and Regulations. And with you is the good Dory Flynn. Good to have you both here.
Thank
Welcome.
you so much, Madam Vice Chair, members of the committee. It's nice to see you again. For the record, Delegate Michelle Guyton, District 42B in Baltimore County, and I'm here to request a favorable report on House Bill 512 to transfer one appointed position on the Professional Standards Teaching Education Board. We also refer to it as PSTEB, from the Association of Independent Maryland Schools, AIMS, to the Maryland Association of Non-Public Special Education Foundation, MANSEF. So those are all your acronyms for today. For several years, AIMS has been informally offering one of these positions to MANSEF, and this statutory change just formalizes this practice. So very simple, at the request of both of those organizations. And you have a letter from both of them in your information. In addition, there was one amendment to this bill. Our House Committee amended the bill to also require that PSTEB and the State Board of Education develop a plan to recruit and retain teachers from historically underrepresented groups. So I thank you for a favorable report, hopefully on House Bill 512, and I'm happy to answer any questions.
Good afternoon. I'm Dory Flynn. I'm the Executive Director of MANSEF, the Maryland Association of Non-Public Special Education Facilities. I represent 70 schools, non-public special education schools across the state, and we're serving 3,800 publicly funded students. MANSEF schools are approved by MSDE under COMAR 13A09.10. Our teachers have to be certified just like our public school counterparts. The actions taken by PSTEB have a direct bearing on the career development paths of the professionals that we employ. MANSEF's representation on the PSTEB board would be a very valuable experience for us. I know that we'll be a valued member of PSTEB. Again, as Delegate Guyton said, we've had an informal agreement with our sister association of the other non-public schools, and they have informally given us one of their slots. This bill's purpose is simply to make it an official MANSEF position and representation on PSTEB. So I urge a favorable report.
Thanks to you both. I actually have a quick question on page 4, lines 12 through 14 of the third reader version, the House version approved. It adds attracting and providing certification to teachers from groups historically underrepresented in the teaching profession. And I wonder if you could speak to what that plan would look like, how that might be accomplished.
Certainly. So this bill, that was the amendment that I referred to, that the committee put on this bill. And that amendment actually just requires the MSDE and PSTEB to develop that plan. So we're not actually writing that in the bill, but we're asking for them to move forward to develop a plan, which is also really consistent with the work we've all done on the blueprint to make sure that we are recruiting and retaining those teachers. Thank you. And I didn't mention this, it did pass unanimously.
True, not even one no vote, I checked.
Not one.
All right, the good delegate was on board. I see no lights, so that wraps up the hearing. House Bill 512, thank you both for being here. Next bill is also Delegate Guyton, House Bill 664, Child Care Programs, Maryland Infants and Toddlers Program, information and assistance.
Thank you so much, Vice Chair Kagan. Again, still Michelle Guyton, and I'm very thankful to be in front of you. I'm here to respectfully request your consideration of House Bill 664, which simply requires that child care centers provide parents and guardians of children under 3 years old with information about the Maryland Infants and Toddlers Program. So this bill has already passed twice through the House. This version is a little bit different than what you've seen before, only that the language is simplified so that all of the different advocacy groups could get behind it and support it. So currently there is no opposition to this bill and only support. And I really appreciate the time of Chair Penske over last year and over the interim to discuss this bill with me, so hopefully it will be in a favorable position for all of you to pass as well. I'm happy to answer any questions that you have about the Infant and Toddlers Program and how this would work, but there's no fiscal note on this bill, there's no opposition to this bill, and again, it also passed unanimously for the third time in the House of Delegates. So I ask for your support for this simple, no-cost bill, which will help us identify children before they get to kindergarten and help give them the intervention that they need to be ready. So thank you so much.
Carosa.
Thank you, Delegate, for this bill. I just want to be clear. So this bill is just providing information, is that right?
Absolutely, and you've heard it in different forms before, which is why it's really whittled down this year and very
It's not
simplified.
pushing anyone?
No,
Okay,
it's
just
offering
providing basic
information to parents, and if they need it, also helping them follow up with making referrals for their children. So simple as that.
Okay, thank you.
Yeah, thank you.
The section starting on page 3 that was deleted by amendment, do you want to just speak to that?
No, I'm looking.
Pages 3 and 4.
Oh, certainly. This was just clarifying because it's a clarifying change so that all child care centers means all child care centers. And so we just wrote that in the definitions and took out this provision that describes it. Really, all that's left in the bill is exactly what I said, which is once a year, the child care centers provide in writing, can be email or in person, that this information and this service is available to children, and that if necessary and if requested, they follow up in helping make appointments.
Super.
Right.
Thank you, Delegate. Clinton
Thank you.
McSherry is going to add his advocacy, his good words. Welcome from the Maryland Family Network. Welcome, Mr. McSherry.
Thank you, Madam Vice Chair. Honorable members, good afternoon. My name is Clinton McSherry, and I'm the Director of Public Policy at Maryland Family Network. I appreciate this opportunity to speak in support of House Bill 664. You have my written testimony, so I'll be very, very brief. In short, early intervention provided by the Maryland Infants and Toddlers Program works. It demonstrably increases positive academic and life outcomes for young children with developmental challenges. At the same time, it reduces the need for special education and other more intensive and expensive services later. As the written testimony from child care organizations in your files will attest, Delegate Guyton is to be commended for working with the stakeholders to achieve the bill's goals while minimizing the burden on child care providers. Maryland Family Network urges your favorable consideration, and I thank you and be happy to answer any questions.
Mr. McSherry.
Seeing no questions, that concludes the hearing on that bill. Delegate Guyton, we have a bill from Baltimore County Delegation, Board of Education member of, member appointments and terms and election of officers. You feel comfortable doing that?
It was not mine.
Is there anybody else here to do it?
Yes, it is Eric Ebersol's bill, and I'm not sure that I remember all of the changes that were made to that, so I might present it incorrectly, but I apologize. I know that the gist of the bill was that we were having some trouble because we have a hybrid elected and appointed school board in Baltimore County. Right, Bill, right here? Okay. And that the members come on and go off at exactly the same time. Yes, that's very helpful. Thank you. Otherwise, it's purely my memory. So what this bill does is actually say that the elected members will go on at the regular time after they're elected, but that the appointed members don't have to go on as have currently before the governor is elected, and can actually wait until February of that next year so that they can be appointed. It's more of a technical problem that we've run into. After this year, the board will be elected in different years as the appointment. So this will never happen again. This is a one-time fix for Baltimore County. And I really hope I remember that correctly. How'd I do, Delegate Banderi? Okay, great.
Thank you.
Thank you so
Seeing no
much.
questions, we'll await a letter from the delegation.
All right, thank you.
That completes that bill hearing. And next up, Delegate Bandari, House Bill 1327, Home and Hospital Teaching Program for Students Report. Welcome, Delegate Bandari.
Oh, thank you. Madam Chair Cagle and members of Education, Health, and Environment Affairs Committee. For the record, this is Delegate Harry Bandari. I represent Baltimore County, District 8. I'm a public school teacher. I've been teaching for the last 15 years. I'm a big fan of education, just completed my PhD in language, literature, and culture. This bill is very important to me, being both as a researcher and educator. In short, this bill, House Bill 1327, Education, Home, and Hospital Teaching Program, would create a work group study the Home and Hospital Teaching Program here in our state and determine if enough is being done to reintegrate the student back into traditional classroom. And the Home and Hospital Program is an educational service for students who have medical, physical, and disciplinary challenges. When students are experiencing such challenges that make our student impossible to attend school, in-person school, and this program lets them continue their education. Based on my 15 years of teaching career, I feel that this program must be improved, and needless to say, in the last 2 years, we have all been on a crash course in virtual instruction and learning from home. The program does not prepare students for reintegration into classroom learning environment, especially in the cases presented by students whose behavioral emotional condition makes it difficult for them to attend school. They miss a lot of classes. I believe just they get very few hours in a week, the instructional hours. These students remain out of school for excessive periods of time. And we are talking about the student who has kidney failure, cancer, asthma, sickle cell anemia, depression, bipolar disorder, and so on and so forth. So on and off during the last year, as I said, that student, they were learning away from the classroom. And I think it is fair to say that there are some things we have learned regarding education outside of a classroom setting that can be used to bolster the home and hospital program. We need to see exactly where the program struggle. Actually, I filed this bill in 2019, passed the House unanimously. And this year, too, it passed the House unanimously and no opposition. Unfortunately, advocate could not be here. And we would like to see where we need the improvement. We may address those difficulties as efficiently and mindfully as possible in the future. In the light of all this, I request a favorable report.
Dari, Senator Hester has a question for you.
Thank you.
Thank you very much, Delegate. I really appreciate this bill. I've been looking at the differences between the two counties that I currently represent. My question is, when you were developing the bill, were most of the home and hospital programs you were looking at, were they mostly virtual, or were they mostly online, or was it a combination, or just in your experience? I know the study hasn't been done yet, but.
Yeah, actually, this bill was carried, did bring to me by parents in Baltimore County. I don't know exactly, they do, but it must be all, because when you go to hospital, some of the kids with the some emotional or some medical, definitely they would have to go. And yes, absolutely, we could do it in person as well and virtual as well, but I can get back to you exactly how this program was implemented in the last 2 years. I don't know exact answer.
If I could just ask one more question. So it's my understanding that in Carroll County,
Okay.
it's not virtual. So it's all you get a bag and you take it with you, or you get assignments. And so I guess I'm wondering if we're going to do this study of what's going on and how effective they are and and how they transition back, would it make sense to you to maybe investigate whether the virtual or the non-virtual programs work better, and whether lessons can be learned from either one?
Thank you, Senator. That's the whole intent of the bill, how we could move forward. This is just a study, and based on the findings, and we could introduce the bill.
Specify, that there is currently a difference between certain counties, and how the different. I understand that's but your intent is to look at how effective they are, but not necessarily to point out the differences between, what's online and what's not online.
Correct.
Okay, thank you very much.
Thank you, Madam Vice Chair, and Delegate, thank you for this bill. I noticed in the testimony that it looked like you worked with the Maryland Hospital Association, who's supporting this, and that it looked like the Maryland Hospital Association had been working with the Department of Health to better define the reasons behind discharge difficulties in this population. I was just a little bit, interested in the coordination that you had either with the Maryland Hospital Association or with the Department of Health.
That's wonderful. Always more stakeholders, then we could the better. We could improve the program. Yeah, they're one of the main stakeholders. Our hospital, our kids, they go to a hospital during their treatment. Absolutely.
Okay, so you'll continue to work with them?
Yes, absolutely.
Okay, thank you.
Questions for Delegate Bandari. So that completes the hearing on House Bill 327. Thank you, Delegate.
Thank you.
And Brad Fallon, you're up next. Okay, so I'm totally biased. I'm just saying I love this guy. So House Bill 139, representing Delegate Lutke, is Brad Fallon. And Felicia Hawkins, if you are here, you can come up and join the good Mr. Fallon.
My understanding, Madam Vice Chair, was that she was not coming.
Okay.
I don't know if she was signed up, but.
Okay, don't know, but she was signed up for both written and oral, so that's all good. Okay, Mr. Fallon, please present 139, Correctional Education, Juvenile Services Education Program, and Correction Education Teachers. Welcome to EHE.
Well, thank you, Madam Vice Chair, for the warm welcome. It was worth the wait here. For the record, my name is Brad Fallon, here to present House Bill 139 on behalf of Delegate Eric Lutke. Some background here. Many teachers in both the Juvenile Services Education System and DJS and the Workforce Development and Adult Learning Division and DPSCS are classified as special appointments. And what that is a quick hiring process that allows agencies to quickly fill vacant positions, which is very useful, particularly in a place that has high turnover, like in these high-stress environments. But once a teacher is classified as a special appointment, they remain with that status. And what the practical impact that is that they're at will and they can't collectively bargain like the rest of their colleagues, despite how long they've been there. So many agencies have moved away from making these special appointments at all. In particular to this bill, the Workforce Development and Adult Learning Division has totally moved away from this, but teachers remain in both systems with that status. So in theory, their colleagues that do the exact same work as them could get paid more, have different working protections, and this is just one more thing that makes it difficult to retain teachers in these high-need systems that are high stress. So House Bill 139 seeks to address this by transferring these existing special appointment employees to the professional service, which allows them the exact same benefits as their colleagues and any other teacher in any other system. As amended, the bill does do two additional things. First, the bill just makes technical corrections in the education article that were necessary to carry out Senate Bill 497 from last year. That was an overhaul of the juvenile service education system. This was part of that discussion and just had to be a follow-up. Second, the bill requires the adult learning division to set qualification standards for their teachers that are similar to those for providing CTE instruction in public schools, and those are the requirements set forth in the blueprint. With that, I'll conclude, and if anybody has any questions, I'm happy to answer those, but otherwise, I'd ask the committee for a favorable report. Thank you very much.
Thank you, Mr. Fallon. So Senator Patterson, followed by Senator Carrozza.
Thank you, Madam Vice Chair. Got his name now. Who's this?
Oh,
this speak-
Brad, Mr.
Brad,
Fallon.
okay, yeah, thank you. Is this program geared mostly for teachers? Would that be like, not inmates, so to speak, you're not going that way, are you? Or no?
No, sir. So interestingly, the workforce development adult learning, the adult classrooms,
Okay.
is actually held underneath the Department of Labor.
Mhm.
So this only impacts that division of it. It just says, it's already so difficult for these systems to retain teachers, because frankly, they're underpaid, and they're required to work 12 months of the year instead of 10, and they're uncompetitive. This is just one more thing that adds some job insecurity. So it just impacts the teachers that are currently working for the system and are not able to collectively bargain and are at will.
Will it be Zoom, or will it be on site, or in person? How?
I'm not sure, for juvenile services, I know it's in person right now. Frankly, I don't know how they do workforce development and adult learning, but again, this bill doesn't impact the operations of the already existing divisions. This just impacts the teachers' classification.
My reason for asking a series of questions, I have a program over there that I sponsored last year, and I ran into a situation where the correction center indicated they didn't have the appropriate expertise and the technical IT is it IT information system, whatever, to conduct it by Zoom, if you will. So I put in an amendment to the bill saying that they had to step up to the plate and do it. I think my friend here was part of that. And I was just curious if you were going through the similar type of loops that I had to go through.
Certainly not for adult learning. To be frank with you, Delegate Lukey has done quite a bit of work with Chair Kelly, who has been just an absolute leader in the juvenile
Okay.
service education system.
Mhm.
That we got into the operations on.
Okay.
This bill was already moving, and then adult learning has to
Okay,
just be
very
included.
well. Thank you very much.
Thank you, Senator.
Thank you, Madam Vice Chair. Thank you for the presentation of the bill, and I know that the whole education issue in our juvenile services has had kind of a history of who's done it over the years, whether it's been Department of Juvenile Services, Department of Education, you've had that confusion. And then, you know, I understand this bill, you're trying to make sure those teachers who were, I guess, brought on in this one classification would then be moved to this professional service in the state personnel management system. So I understand that. My question is, what, given that this impacts Department of Juvenile Services and the Department of Public Safety and Correctional Services, what was the coordination with them on this bill?
Yeah, so I'll start with adult learning. That, again, interestingly, that's actually housed under the Department of Labor. When we first contacted the Department of Labor on this, they weren't necessarily aware that they still had special appointment teachers because they had made an internal policy change some time ago to move away from hiring anybody on that status. When we pointed out that they did have several teachers, they were happy to have them transition. As far as DJS, we work very closely with them. They didn't take a position on the bill. However, the Juvenile Services Board of Education came out in support of the bill, who runs the juvenile service education system now.
Came out in support of transferring
right.
them to the professional service?
That's right.
Okay, thank you.
Yes, ma'am.
I see no other questions. Mr. Fallon, thank you for being here. Sorry if I was too familiar, you guys. Brad was an intern in my office many years ago, and he has just flourished, and so it's always a pleasure to welcome him back. So thank you. I will see you again soon. That completes the hearing on House Bill 139.
Thanks, everyone.
Okay, ladies and gentlemen of the committee, that completes our hearings. We are going into a voting session, and we have a major concurrence, which, or not to concur on. So